number 197, the people of the state of New York versus Immanuel Flowers. Counsel?
Good afternoon, Your Honors. Lawrence Hausman for the appellant, Immanuel Flowers. I would like to reserve 2 minutes for rebuttal.
You may, sir.
Your Honors, on the first appeal in this case, the appellate division concluded that the sentencing court had improperly relied on dismissed conduct, the shooting of the complainant, in imposing sentence. And so the central question on this appeal is whether at the resentencing the court continued to rely on the dismissed conduct. And we think there are two compelling reasons in the record for concluding that the court...
I'm sorry, I should have let you get to your two reasons, but what stops me at the get-go is that the appellate division disagreed with you. Isn't that, like, endgame there?
I don't think so, Your Honor. I don't think this is a mixed question. I think the record strongly supports...
But your argument is that the trial court disobeyed the mandate of the appellate division.
Right.
And the appellate division itself, when that question was brought up to it, said no, didn't do anything wrong.
But I think, Your Honor, that the appellate division was wrong the second time around, because I think the court did exactly the same thing it did the first time. It was a little more careful the second time. And so, I think it's a good segue to the two reasons. And one is, I think was...
Counsel, did the appellate division have to remit or remand the case to the Supreme Court to resentence after it found that initially that the court had used an improper basis for the sentence?
Was it obligated to?
Yeah.
I think it could have exercised its discretion and through its excessive sentence power and reduced it. But typically, in this situation where an appellate court finds that a court relied on an improper factor, the typical remedy, at least, is to remand, to give the resentencing another opportunity to resentence.
So picking up on what Judge Stein said, if the appellate division had believed that the trial court didn't follow its mandate on remand, it could have at least exercised its interest of justice jurisdiction the second time around and reduced the sentence, right?
It could have, and it didn't. But I still think that just like the trial court is capable of making errors, I think in this case the appellate division error the second time around, the appellate division the second time around did make an error. And just to get to the two reasons,
I'm sorry, it's not preserved, right, this objection?
Your Honor, it was not preserved by defense counsel, and that's why we argued that there are two ways to review this claim. First of all, we argued that this court should recognize a narrow exception to preservation when an issue is explicitly remanded to a trial court for a specific reason. We feel that under those circumstances, the trial court is completely alerted to what the issue is, and so it knows what it's supposed to follow.
But it's the same defense counsel, right?
Yes, Your
it's
Honor.
the exact same lawyer.
It was, Your Honor.
These arguments, understands why it's being sent back, and the lawyer doesn't raise this issue?
Well, that's why we alternatively think the court could review the merits through the lens of ineffective assistance of counsel. And in fact, on appeal, on the first appeal, on the second appeal, the counsel who we're saying is ineffective was going to raise this issue in the interest of justice, and then the client has to have counsel relieved because the issue wasn't preserved. But
to go then to Judge Stein's point on the ineffective assistance claim, you have an appellate division that says you would have lost on the merits anyway.
Right.
So it seems hard to fault a trial lawyer as ineffective when the law, at least as the appellate division takes it in that department, is exactly what he thought he wouldn't have won.
And I think my answer to that is to go back to the two reasons that I just wanted to try to get out there as to why we think the record strongly supports the notion that the court continued to rely on this improper conduct. One is, and we think there should indeed be a presumption to this effect, that if the court, having been found to rely on improper conduct, imposes the same sentence again without any new bad facts in the record, we should presume that the court is again relying on the improper conduct. And the reason is because I think it's reasonable to assume that when a court imposes a sentence and articulates an aggravating factor, that aggravating factor affected the length of the sentence. And so if we subtract that aggravating factor...
Isn't it just as reasonable to assume that this particular, if that was the only factor the court had given in its explanation for how it was sentenced, you know, I think you'd have a much stronger argument. Here, the court enumerated several factors, and isn't it just as reasonable to assume that any one of those factors might have resulted in the same sentence?
I think not, Your Honor, because I think that it's reasonable to assume that each aggravating factor relates to the length of the sentence. It's like a scale. I mean, I think when you do sentencing, you have a bunch of aggravating factors and a bunch of mitigating factors. If one of the aggravating factors, one apple is, rotten, and you take it off the scale, it should affect the weight. It should affect the length of the sentence. And I think.
But you're assuming that when you're doing this weighting you're talking about, you get just to the point where it justifies the sentence, as opposed to it may indeed be more than was ever necessary to justify that sentence. And the judge is running through sort of the history and what's being weighed, but it may not be that not focusing on what the judge shouldn't have focused on, as the AD made clear, still doesn't get you past the point where the sentence is justified.
Well, a couple of points. I think that if you're looking at the integrity of the sentencing process, and you have a court reaching a certain sentence and relying on an improper criteria, when the court is no longer allowed to do so and reaches the same result, I think the perception is that the court is continuing to rely on that.
So what should have happened then, in your view?
I think the court should have imposed a lesser sentence.
Well, that I was willing to bet you would
Yeah.
say. But I mean, now, let's assume the appellate division says what it says and says, all right, we're sending it back.
Yeah, I think you should send it back for resentencing so that the court, preferably at this point in front of another.
I'm back to what you're complaining about. So the appellate division says, we're going to send it back for resentencing. Do you need a new judge because you've now aggravated the judge who sentenced him by saying he was wrong? What do we do in the future when something like this happens?
Court cases are often sent back to the same judge even when they make mistakes.
Right.
Sometimes the mistake is so sort of egregious in certain circumstances, a court will conclude that a judge is so vested in the mistake that they will send it to another court. That's a discretionary matter. I don't think it's required in this context, although perhaps on the third time around it would be the best.
But I'm just trying to figure it out because, as Judge Rivera says, he may have wanted to give you even more. But, the sentencing guidelines don't allow him to do more.
Well,
so.
he didn't give the maximum, Your Honor, so he didn't want to give more, or he would have given more the first time.
All right, then let's make it the next case. So, did the appellate division then say you have to give less time than you gave the first time because the first time you used factors that shouldn't be considered?
I think that should be, I don't know that the court has to articulate it that way, but I think this court should articulate that absent new bad facts, there should be an improper fact, should be in essence subtracted from the length of the sentence. Trial judge gets to decide what that length is, but I don't think you can say it's zero. I don't think you can.
So is your argument, just to be clear, is your argument that every time or whenever a judge mentions a fact during sentencing that should not have been mentioned, that on resentence, that defendant is automatically entitled to a lesser sentence? Is that your argument?
Absent new bad facts, and I'm not saying it's a significant reduction, but I think it's a prophylactic protection against the resentencing court ignoring the appellate court, and it's also a recognition that when a court, in this case, the court said, I'm sentencing the defendant to X because of, and he listed 4 or 5 reasons, and I think each reason, it's reasonable to assume correlated with some increase in the length of the sentence.
Your assumption is that the court listed every reason that could possibly be listed for the sentence initially given.
No, there may have been other reasons too, but what I'm saying is once a court...
Right, so if on the resentence, the court then comes up with a new, according to you, the court has to come up with another reason, but that has to be new bad facts.
The reason it has to be new bad facts is because I think it's fair, the concepts of due process and fundamental fairness, for the resentencing to reflect the fact that the court is no longer relying on an aggravating factor that's improper and that it pointed to as being part of the reason it gave the sentence it did.
So to that point, that sentencing proceeding, the judge is entitled to a de novo review of all the facts and come up with his or her determination, correct?
Yes.
Isn't that entitled to a fresh look and a fresh perspective?
Well, I think just like in Van Pelt, when a case comes back after a reversal, and the judge isn't allowed to penalize the defendant, you could say, well, it's a de novo resentencing. The court can do whatever it wants. But nonetheless, we say, well, yeah, but if the sentence goes up, we're going to presume it's because the court is punishing the defendant. Maybe the court's not. Maybe the court is taking a fresh look. But I think there's a significant enough risk there that the court is punishing the defendant. Here, when there's no new bad facts and you arrive at the same sentence, but you're no longer allowed to rely on this improper criteria, I think there's too great a risk that the court is continuing.
So would the court on resentencing have also, in your opinion, under your analysis, have made an error if the court had said, pursuant to the appellate department's decision, I am not taking X facts into consideration, but based on the other facts and the other issues that I recognize at the prior sentencing, I sentence the defendants to any sentences, again, to the same sentence. Would that be a violation of
I believe it would,
client's
although
rights?
one thing I've never gotten to yet is the fact that and I guess I'll get to it on my rebuttal.
Why don't you save that for rebuttal?
Is that there was another reason in this record to conclude that the judge was continuing to rely on the code of conduct. But I think the reason in answer to Judge Rivera's hypothetical is that in that situation, we're assuming that the reliance on the aggravating factor didn't contribute to the length of the sentence because the judge already had all those other facts.
Thank you, sir.
Thank you.
Counsel?
May it please the court, Avshalom Yotam for the respondent. Defense claim here is ineffective assistance. Defendant did not object at the resentencing. Objection was required. And the rule that is now being proposed to get around the preservation requirement is ultimately unworkable. It can't be that every time a party thinks that a remittal order has not been complied with, that nonetheless it doesn't need to bring that objection to the court's attention, because that just sort of defeats the purpose of the preservation requirement.
Could the appellate division have remitted and said that you improperly considered this factor, and we're sending it back, and you must sentence the defendant to a lesser sentence?
Well, I guess I'm interpreting your question in two ways. If the question is about exercising its power to reduce a sentence, we would be, I guess, in a different situation. I don't think, by the way, it was inappropriate for the appellate division to, even if it suspected it might want to reduce the sentence, to forbear and not to do that, because in fact it was protecting defendants' rights. I mean, as soon as the appellate division decided, we're concerned about how the sentence was determined, defendant got a right.
But you're not questioning whether the appellate division could have done that. And then if it had done that and the trial court persisted in sentencing him to the same sentence, then it would be clear, right? Meaning
if instead of exercising its power to say this is the sentence, if it had said reduce the sentence, you reduce the sentence.
But you decide what it is, but it has to be less than what you did the first time, right?
Yeah, that would be a different situation.
But it didn't do that.
No, it didn't do that.
Okay, so does that tell us that it was telling the trial court that it could exercise its discretion without that limitation?
Yeah, that's certainly our approach. And in fact, as you're suggesting, it is sort of an unusual situation where we kind of want to rely on the order that you're reviewing, as you're sort of revealing something about how the appellate division is approaching these cases in general, whether it thought its authority was being defied, what defense lawyers think. I mean, if the appellate division wasn't seeing anything wrong here, it was so, a reasonable defense attorney would not have, hearing everything this attorney heard at the resentencing.
You see the logic, though, of what the appellant's saying? I get 20 years, and they say, I'm giving you the 20 years, not only because of what you did, but because even though the jury acquitted you of this, I think you did it, and I'm going to give you 20 years. I know I'm not saying exactly. So it goes up to the appellate division. The appellate division says, you can't do that, sends it back, and he says, I'm giving you 20 years.
Yeah, well, so, I think ultimately the answer to that is Young, and the cases that follow Young, which explain, Even where a conviction has been reduced, counts have been taken out, the case comes back for resentencing, the same sentence can be handed down. And
But
those.
shouldn't the judge say, I'm aware of what the appellate division said, I'm not going to take into consideration those other factors. However, my review is, and then he brings out the 3 or 4 that he did this time. So at least there's some record showing, that he's correcting whatever the appellate division suggested.
Yeah, no, it's interesting. It sounds like the defendant is reading the record and saying Judge Maris knew what he was doing and he was thumbing his nose at the appellate division. We also say.
Because the follow-up to that is, if that's true, then counsel was ineffective for just standing there while the judge gave him the exact same sentence he gave him before, with 3 or 4 of these things that may or may not have been part of the record in the original sentence, right?
Right. So, right. But we read the record, and we think a reasonable defense attorney could read the record or hear Judge Maris's comments and say, oh, he knows what he's doing, and he's actually clarifying what his thinking was. He's addressing the appellate division's concerns. He's saying, you were worried that I'm considering facts relating to the dismissed count improperly. No, there's a certain proper way, even under New York law, to consider these facts. There's no blanket prohibition on considering facts that relate
Saying
to.
on the record that
Well, no, he
counsel could have, during this resentencing, have interpreted the judge to do exactly what the appellate department had directed the judge to do, that there's a way to read that record, and that the counsel read that record in that way and was going about the business of trying to persuade the judge that a lower sentence was appropriate,
Right,
given the history of this defendant.
Right, yeah, meaning from an objective point of view, a reasonable defense attorney could ignore all the, both claims that are being proposed now and just focus on what this defense attorney focused on, and she did a very good job at it, argue for a lower sentence, which is what she had achieved for her client on the first appeal. And I just, for this idea that facts relating to dismissed or acquitted counts can be considered at sentencing, we're relying very much on this court's decision in Horn. We cited Horn in our brief for the easy proposition that the facts that relate to let's say, an acquitted count are not exclusive to that count. They can also actually prove, prove the count in which defendant is convicted, and so the sentencing court is actually explaining its reason or commenting on the strength of the evidence. But beyond that, these facts can also be relative circumstances of the crime, and they're also informative to the sentencing court about the defendant in front of it. And Horn is 97 New York 404. And the discussion that I'm referring to is at 413, where this court explains, just because there's been an acquittal on a count doesn't mean that the facts that are relevant to that count disappear. And then as for just the idea in general of a presumption of vindictiveness or anything like a presumption of vindictiveness, I mean, any kind of imputation of an improper motive, at least with the actual presumption of vindictiveness, there's a kind of intuitively remarkable fact that there's been defendant has appealed, had a successful appeal, and then he's resentenced and gets a higher sentence. I mean, there's something, remarkable about it, at least intuitively. But I mean, what exactly are the circumstances here that suggest any kind of likelihood of, vindictiveness, retaliation, self-vindication?
Well, when you send it back, you assume that you'll get a fresh evaluation. But if there's no real evaluation, you get the same time, then that would be I thought that they were backing off a little on the presumption of vindictiveness, but at least alleging a presumption of impropriety of some kind.
The defendant?
Yes.
Yeah, well, I mean, what
normally what would happen is quite often in the appellate division, you'd send it to a different judge, and that would solve the problem usually.
Well, even in this case, though, given this was the judge who dismissed several counts of the indictment and only left one count in the context of vindictiveness, would that be some factor that should be considered about whether the judge was vindictive or not, or whether there was some kind of vindictive institutional position here?
Right, I mean, there are several circumstances that sort of argue against any kind of, worry about an improper motive. It's, the conviction hadn't changed, and the judge didn't change the sentence. And then the judge was very much aware, as Your Honor is suggesting, was very much aware of what facts could be considered that related to the dismissed counts, because he himself had dismissed that count, and he, when he did so, he explained explicitly, people's case does establish that the gun had been fired. It's just I'm worried about intent, and I'm going to dismiss those counts for that reason alone. And then, if we're right that there is no blanket prohibition on considering facts relating to dismissed or acquitted counts, that's also relevant to this question of improper motive, because Judge Maris was, as we read it, was clarifying. Look, if you were concerned that I was considering something improperly, the first thing he says, look, this is the evidence, a gun was fired, there is a proper way to consider these facts, and that's what I'm doing.
Thank you, counsel.
Thank you very much.
Jasmine?
Yes, Your Honor. The other thing I wanted to point to, other than the reimposition in the same sentence, which I never got to, was the fact that the judge referenced the shell casings which were recovered from the scene of the shooting. And I think in context...
Wasn't that relevant to the criminal possession charges, though?
Only in the most abstract way, and Your Honor, it was superfluous to the issue of simple criminal possession of a weapon, but it was highly relevant as a way of suggesting that the defendant was involved in the shooting. I mean, if the judge wanted to...
but the court dismissed the other charges based on a lack of intent, not on lack of proof that in fact the gun was fired and hit.
Your Honor, right, well, what the judge said specifically, the judge said a couple of things. The judge said that, because don't forget, the judge dismissed a range of charges ranging from misdemeanor assault all the way through felony assault. And if the judge had thought the charges supported a reckless conduct under the dismissal statute in the CPL, he would have reduced it to the lesser offense, because that's what legal sufficiency determination involves. But what the judge said was that the circumstances, this is on A231 of the record, A281 of the record, the circumstances of the actual shooting are subject to speculation here. So in other words, what the judge is saying, we have no witness to the shooting. We don't know what the circumstances of that shooting were. And so the shooting of a gun can range from the most culpable act imaginable to a justified act or an accidental act. And without knowing what that is, there's no basis for assigning culpability. And so that's why we think the reference to the shell casings is critical in this case. Shell casings that are recovered from the scene of the shooting are highly relevant to connecting the defendant to the shooting. They're entirely superfluous on the issue of simple possession, particularly in a case where, you had a witness who testified entirely about the operability of the weapon. If the judge was concerned with the operability of the weapon, that's what the judge would have talked about. To talk about the shell casings at the scene of the shooting.
But he can be concerned that the weapon's loaded, right? If you were a possession count and the weapon's loaded, that's a legitimate factor in sentencing, right?
And the judge was entitled to rely on that.
And what about it's been recently fired? You're walking down the street, you have a loaded gun, and that gun's been recently fired. Can they rely on that?
The reason I would say not is because then you have to speculate about whether the conduct was, to affix culpability, you have to speculate. Was it fired justifiably, accidentally, or was it fired with intent? And if you don't know that, I don't think it provides a basis for affixing
Could the shell
culpability.
casings coupled with the Department of Probation's report saying that your client was a danger to society, could that be considered? Could it be considered in connection with that?
Not in connection. The pre-sentence report could be considered, but what we're saying is that in this case, as the appellate division held the first time around, and as is the law of this case, and not reviewable, the shooting of the victim was not a proper criterion for sentencing in this case. And what we're saying is that not only...
What I'm asking, counsel, is the probation or the pre-sentencing report indicating that your client was a danger to society, could that be considered in connection with a gun recently fired for whatever reason?
I think that no, because I think that ultimately tying it to the recent shooting of the gun without knowing the circumstances of the shooting and whether or not the fact that the gun was fired is related to any culpability doesn't provide a
Well,
basis
even
for.
if it was accidental, wouldn't that be related to a possible danger to society if this guy's running around? And maybe it's not criminal culpability, maybe it was negligent. I mean, any circumstance in which a loaded gun is being carried and is fired, regardless of what the level of culpability is, wouldn't that be relevant?
I think you'd be right as to the carrying around the loaded gun, but that was, but not as to it being fired, because without knowing the circumstances of it being fired, because it could be that it's not related to any culpability regarding sentence, and we just don't know here. That's what the appellate
Except
division
that it's
found
an
the first
illegal
time.
weapon, except that it's possession of an illegal weapon on a public street.
And absolutely, the fact that he possessed a loaded illegal weapon on the street is completely relevant to sentencing. But I think our ultimate point is that the judge knew that at the first sentence, knew that at the second sentence. No other facts changed, and yet we had the same sentence. But that sentence continued to rely on, we believe, on the dismissed conduct. And that's shown not only by the fact that the same sentence was imposed, so there was no accounting for that impropriety, but also the fact that the judge expressly references these shell casings, which really the only meaningful impact, relevance to sentencing they had was to connect Mr. Flowers to the shooting of the complainant, something the appellate division had said was expressly prohibited.
Thank you, Mr.
Thank you, Your Honors.
Thank you.